Good afternoon, everyone, and thank you for inviting me to participate in this important symposium and, more important, this discussion on policies, at least from the U.S. perspective. My name is Courtney STOPP. I am a patent attorney at the U.S. Patent and Trademark Office in our Office of Policy and International Affairs. And today I would like to talk about the important role of IP in innovation policies. And in particular, I'm going to focus on policies that support greater access to the global patent system. So much of the day has been spent talking about the importance of IP and patents and what it means to companies. And from our perspective, we need to make sure that in order to obtain those IP rights, we make it as easy and accessible as possible. During this talk, I will touch on the importance of technology in the US. I will also look at innovation and the role of government and in intellectual property policies. And finally, I will discuss how a fundamental policy for the IP system must be the ease and access of patent rights to all innovators wherever they are doing business. First, let me begin with the importance of technology in the United States. We often proudly boast how the United States is the first nation to write a patent system into its Constitution. Article 1, Section 8, Clause 8 of the United States Constitution grants Congress the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Prior to and while advocating for the ratification of the Constitution, one of our most famous founding fathers, James Madison, wrote of Article 1, Section 8, Clause 8, that the utility of this power will be scarcely questioned. The copyright of authors has been solemnly adjudged in Great Britain to be a right of common law. The right to useful inventions seems with equal reason to belong to inventors, and the public good fully coincides in both cases with the claims of individuals. In my opinion, Mr. Madison and myself are making the same argument, just 230 years apart. Inventors must have access to the exclusive rights of their own inventions. Only now, however, I have the benefit of substantial data to back this up. Multiple studies and conversations just today recognized that IP-intensive industries support growth, support jobs, support wages, support GDP growth, research and development growth, investment growth, just to name a few. With the ratification of the Constitution in Article 1, Section 8, Clause 8, the prominent role of patents and IP was established in the United States. A continual question since then is, what role should government be? How does the work of government continue to promote the progress of science and useful arts? Well, a lot has changed since the ratification of the U.S. Constitution, but at a fundamental level, the U.S. government operates as originally established. The Constitution created our three branches of government: the legislative branch, the executive branch, and the judicial branch. Each of these branches has a role in accomplishing the goals established by our Constitution. And while the interplay of those branches can be complex and nuanced, to say the least, I will do my best to quickly and succinctly summarize each of their roles. Our legislative branch writes and enacts all federal laws and statutes. Our executive branch develops administrative rules and procedures via government agencies to ensure that they can accomplish their mission within the laws and statutes. And our judicial branch ensures that all of this complies with our Constitution. Within this framework, and without being exhaustive, many agencies within the government will play a role in developing IP policies in the United States. That includes the United States Patent and Trademark Office, the United States Trade Representative, the Department of Justice, Health and Human Services, the National Institute of Technology and Sciences, the Food and Drug Administration, and many more. The United States Patent and Trademark Office is part of the Department of Commerce, where we fall out under the executive branch of our government. And we are bound by the laws of Congress and the rulings of the Supreme Court. The USPTO's mission is to foster innovation, competitiveness, and job growth in the United States by timely patent and trademark examination, review proceedings in order to produce reliable and predictable intellectual property rights, guiding intellectual property policies, improving intellectual property rights protection, and delivering intellectual property information and education worldwide. In this capacity, the USPTO has the authority and responsibility of prosecuting and granting patents and trademarks, advising the President of the United States on all matters regarding intellectual property, and engaging external stakeholders in the development of both domestic and international intellectual property policies. That's not a small task. But as mentioned before, today I will limit my focus on one small topic with very large impacts: the access to the patent system. What do I mean by access to the patent system? That seems pretty simple. But really, the basics that I am referring to are policies that ensure that meaningful patent protections are available to innovators wherever they are doing business. These policies should work to remove as many obstacles and challenges as possible in terms of administrative, procedural, and substantive hurdles. They should work to ensure that inventors receive their rights in a timely fashion. They should work to ensure that by receiving rights in one jurisdiction or applying for rights in one jurisdiction, you do not preclude yourself from rights in another jurisdiction. And that innovators, large and small, can enter the system and benefit equally. The good news is that there are several mechanisms already in place for improving access to the global system. These come in a variety of forms, including treaties, mechanisms for reducing backlogs and delays, forums for promoting substantive patent harmonization and harmonizations of practice, and support for small to medium enterprises. Beginning with treaties, each of the treaties listed here breaks down barriers for innovators protecting their inventions around the world. The Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS, established minimum standards for the protection and enforcement of intellectual property rights for members of the World Trade Organization. The Patent Cooperation Treaty, or the PCT, reduces the burden to applicants by establishing a means of applying for patents all over the world on the basis of one single application. The Paris Convention, the oldest of the treaties listed here, established fairness through national treatment clauses and recognition of priority claims and priority documents. And the most recent, the Patent Law Treaty, harmonized and streamlined the formal procedures with regard to regional and national patent applications, making the overall global system easier to use. In dealing with backlogs and delays, the international community has actually made great strides in the last several years via work-sharing initiatives. Backlogs and delays in major participating jurisdictions have been substantially reduced in the last decade. When this work began, the backlogs in offices around the world were exploding. At the same time, we were starting to see the increase in applications filed in multiple offices at around the same time steadily increasing. And this led to a substantial amount of duplication in work on common patent applications and created inefficiencies in the system around the world. So what does work sharing actually do to ease the access to the patent system? Well, it's a way that offices seek to reuse search and examination results completed on related or cross-filed applications in another office to minimize the duplication of work, to enhance examination efficiency, and to enhance quality, delivering real, cost-effective, and timely results to the end user. Although various work-sharing initiatives, including programs associated to the PCT and other collaborative search projects between the USPTO, KIPO, the JPO, have shown great benefit, we also have the Global Dossier that allows users to have access to the files. The most prominent of these has been the Patent Prosecution Highway, or the PPH. The PPH partnerships among IP offices around the world are key to providing higher quality examinations faster, with more predictability and a reduced cost. When a PPH partner office finds one or more claims allowable in an application, the applicant may request a fast-tracked examination in another partner office of a corresponding application containing the same claims. By reusing the search and examination results from the first office, the second office can avoid a duplication of work, speed up its own examination processes, and improve their quality. And while I would like to say all offices participate in this, and we have dramatically increased usage, we can still advocate around the world for more offices and regions to participate. The bottom line is that with the PPH, applicants' access to the patent systems around the world is made substantially easier, as well as the fact that applicants save money. The benefit of that, these savings are then invested into future projects, generating new technologies and stimulating economies. There we go. Next, there are continuing efforts in a variety of forums to establish both substantive patent law harmonization and procedural patent harmonization of examination practices. Without getting into a lot of the details, substantive harmonization is currently focused in areas such as prior art, grace period, publication of applications, conflicting applications, and prior user rights. I think the most important part for today's talk, however, is the objective of these efforts. And it's to create a more transparent system, allowing inventors to use the same principles, same procedures across markets, and essentially become more cost-effective and easy to navigate. The principles of harmonization efforts establish that the global patent system should be coherent and balanced by offering fair levels of protection for inventors, applicants of all backgrounds, large or small, private or public, universities and research facilities, providing a fair balance of rights between inventors and applicants and third parties, promoting high-quality patents by ensuring the patent protection is provided only to inventions that are new, involve inventive step, and capable of industrial application, but most importantly, they must support economic growth. Finally, small and medium enterprises are the heart of the economic growth, and in the United States, they make up approximately 20% of our patent filings. Supporting SMEs is essential to supporting economies. In the US, we have a variety of programs within the PTO to support the needs of SMEs, beginning with fee reductions in filing, issue, and maintenance fees for small and micro entities of 50 to 75%, respectively, for each, a pro bono program for financially under-resourced independent inventors and small businesses in states across our country. Under this program, attorneys in states and regions around the country actively work to provide the legal assistance necessary for those who need the most help in navigating a complex patent system on a pro bono basis. There is also an Inventors Outreach Center providing patent information and access to the public. The center is staffed by our own former supervising patent attorneys and primary examiners who can answer the public's general questions on patent examination and policies. The USPTO actively engages in outreach, education, and trainings to SMEs via the web, roadshows, and in-person on-campus trainings. And last but not least, providing a robust grace period policy ensures that small and medium enterprises can make economic decisions that allow them the time necessary to test their inventions in the market. With that, I will conclude that one of the main roles of governments should be to play an active and participating role in ensuring necessary access to the global patent system to all users, both domestically and internationally, and supporting other offices in their efforts to do so as well. I thank you again for this opportunity, and I look forward to hearing from my other colleagues. Thank you.
네, 세계에서 가장 건강한 혁신 생태